Hello, everyone. Welcome back to another episode of Terms and Conditions, a podcast by Con Maciel Carey. Our goal is to demystify workplace law in a grounded and accessible fashion to help you be an employer of choice. My name is Letitia Silas, and I am a partner in the Con Maciel Carey office in Washington, D.C. Today's discussion is going to focus on the importance of understanding the Fair Labor Standards Act. And for this discussion, I am joined by two of my colleagues, Scott Hecker and Lindsay DiSalvo. Welcome, Scott and Lindsay.
Hi, Letitia.
Hi, Letitia.
Why don't you just take a minute to share a little bit more about yourselves and your practice at Con Maciel Carey with our audience?
Go ahead, Lindsay.
Thank you, Scott. As Letitia said, my name is Lindsay DiSalvo, and I'm a partner in the Washington, D.C. office as well. And I'm a partner in both our workplace safety practice and our employment and labor practice. And as it pertains to our discussion today on the employment and labor side, I've assisted many clients with reviewing pay policies, reviewing exempt classifications of workers as independent contractors versus employees. I have helped employers audit those programs and policies at their workplaces, and I have assisted in litigation where those issues are raised as well.
All right, Scott?
Yep, thanks, Letitia. Thanks, Lindsay. I'm senior counsel also in our Washington, D.C. office, both in the safety, workplace safety groups and the labor and employment groups, certainly focusing on wage and hour issues on the labor and employment side. I spent about a dozen years at the Department of Labor, including a couple stretches in the wage and hour division. So have seen a lot of these issues both from the agency side as well as working with employers on compliance and litigation.
All right, so just as an umbrella issue, why is understanding this law, the Fair Labor Standards Act in particular, important for employers?
I think because employers want to make sure that they're properly paying their workers, the folks who are on the ground executing for them every day. And it can be a complex area of the law. You want to make sure you're meeting the minimum wage and overtime requirements that the FLSA dictates. And we're here to help with that. Certainly, we're here to, as Letitia said, demystify some of the confusing and difficult compliance aspects of the act for our clients. But yeah, I mean, I think in general it's important that we're doing the best we can on the employer side to meet our obligations and make sure our teams are properly compensated for their work.
And how about for you, Lindsay?
Thanks, Letitia. I would just add that I think it's also important from a potential exposure perspective for employers. It can be a very expensive litigation process, as well as, if we reach settlement or if we go through the whole litigation process to trial, the ultimate outcome, if employees are successful in showing that they weren't paid properly because they were misclassified or because overtime wasn't being paid properly, for instance, that can be a really expensive outcome for employers. There are high damages that are possible under the Fair Labor Standards Act, as well as we'll talk about this a little bit today. Many states have their own laws on this issue and their own requirements for how employees are classified, their own requirements for how employees are paid. And that can be very expensive as well, as far as the potential damages that could be owed if an employee is successful in proving their case.
Great.
And I just want to add, we've set ourselves up now. I'm the good cop and Lindsay's the bad cop.
Yeah. Well, you know what? I think the good cop is going to deliver the news about the potential risk to my organization and why if I'm a business owner, I'm an employer, why I want to make sure that I am compliant with this very, very critical law. And for the purposes of this discussion, we're going to be focusing on the FLSA, which is a federal law, and just like Lindsay talked about, states will have their own wage and hour laws as well. So it's not enough to just know the Fair Labor Standards Act. You also have to know what's happening in your state. All right, so let's just start as an overview here. So I think we touched on it already, but just so that everybody's clear, what is FLSA all about?
Yeah, I mean, I think yeah, sure. No, quick answer on this act that's been around since the 30s. But the Fair Labor Standards Act is really primarily, I would say, a minimum wage and overtime law. It's about compensating folks for the hours they work, and the Wage and Hour Division at DOL is the federal agency that administers the act. So the enforcement side of things, they're the ones who conduct investigations. They can bring actions, as can employees under the act, to recover things like back wages that maybe were not properly paid. And so, it's important to be aware of the requirements, the standards under the act, so that you are meeting those and ensuring proper pay and mitigating your enforcement risk. But yeah, I mean, primarily it's an act designed to protect workers and ensure that they are properly paid for the hours they put in for their employers.
Excellent. So Lindsay, what employers are covered by this law?
This law covers pretty much everyone. There are some very limited exceptions, but a private employer is generally going to be covered by the Fair Labor Standards Act. And that it goes the same way for employees too. There are exceptions, and we'll talk a little bit about some of the exemptions for certain types of employees, but it is generally applicable to employees as well.
Excellent. So we are going to dive into how employee is defined, and Scott and Lindsay are going to help us with that. But before we go there, one of the exciting things about this discussion is that you both are just returning from the ABA Wage and Hour Conference. And so can you just briefly share with us some of the updates that you learned at that conference?
Yeah, I think, we definitely enjoyed our time at the meeting. There's a lot of information exchanged. I think the biggest takeaway for me actually does go to some of the state requirements we were alluding to. Unfortunately, we didn't have our federal employee colleagues at the meeting, and so it was not as clearly presented what their current priorities may be, though we do obviously have insights into that based on the first Trump administration, other publications that are out there reflecting and actions taken by the Trump 2.0 administration on where their priorities are. But we didn't get that straight from the horse's mouth this time. I do think the ABA recognized that. They did have some folks who have prior government experience that sort of tried to read the tea leaves, but I think some of the state information that was provided, some of the differences, some of the gap filling that's being done at the state level, those were takeaways to me that were really important, because the Fair Labor Standards Act, as you alluded to, Letitia, is really the floor for wage and hour law in the country, and you see states acting to backfill maybe enforcement gaps, or so many jurisdictions, including states and even cities, have their own wage and hour laws and minimum wages that can really impact multi-jurisdictional operators, multi-jurisdictional employers. And that's why you do need to be aware of these things. And so we saw that. We heard about, state activity in the minimum wage space. I think child labor is another area where you see states sort of taking a more active role, where maybe the Fed is not as invested as it was in that particular issue during the last administration. But yeah, there's opportunity for the states to step in here in our federal system and sort of raise the floor that the FLSA sets.
I would say another big takeaway from the conference was the role that courts play in how the FLSA is applied and interpreted. There is the Fair Labor Standards Act, the FLSA, and then there are numerous regulations that give some more information on how the law should actually be applied. Mm-hmm. Then you have the courts that come in and they're telling you, what some of these terms mean in more detail, how they actually are applied in our workplaces, depending on the type of workplace, depending on the type of employer. And so, there are a lot of ongoing cases and recent litigation that sort of provides some better understanding to how some of these things, at least in certain places, wherever these courts are located, how they're going to be applied in that space. So I think that was an interesting discussion as well, and will certainly, inform some of the information that we'll share today on some of the specific issues we talk about.
Excellent. So my takeaway from both of you is that, one big overarching thing from that conference is that it's not sufficient to just look at the website, the DOL website. Like if you're just looking at the DOL website for guidance, that is just not going to be sufficient to protect your organization. You really need to understand what the courts are doing. You need to understand what the agency is doing. You need to understand what your states are doing. And that would likely require some assistance from counsel whose job it is to know all of those things. It looks like although there wasn't much on the federal level in terms of what's communicated at the conference, there was something happening in the background, and that is a proposed rule on the definition of an independent contractor versus employee. So Scott, why don't you lead us into that discussion by first starting with how employee is defined and then talking about this proposed rule?
Sure. I often refer to the sort of fact that we learned in kindergarten that you shouldn't define a term with the term itself, but employee under the Fair Labor Standards Act is any individual employed by an employer. So you tell me what that means. Employer includes any person acting directly or indirectly in the interest of an employer, there we see it again, in relation to an employee. Anyone acting in the capacity of officer or agent of such labor organization is not covered. So you got that. Letitia, you can speak more to the labor side of things, but basically, as Lindsay said, any kind of private actor is going to be potentially an employer under the broad definition, and an employee is someone employed by that employer. So the big issue for independent contractors and the independent contractor rule is when is someone not an employee, so they are not subject to the requirements of the Fair Labor Standards Act. And the notice of proposed rulemaking that was issued at the end of February by the Wage and Hour Division addresses that issue, which has been kind of in flux to some degree as the administration has gone from Trump 1 to Biden to Trump 2. President Trump issued an independent contractor rule in 2021 that was then rescinded by the Biden administration, which issued its own rule in 2024. And now we're back with a rule that's pretty similar in this the proposed rule of 2026 is similar to the 2021 Trump rule in that it puts increased probative value on two factors in what is more broadly viewed as an economic realities test. And those two factors are control and the opportunity for profit and loss for the worker. So if the employer is exercising control over the worker, if the worker doesn't have real opportunity to sort of change their own opportunities for profit or loss, they're likely going to be an employee. On the flip side, if they are kind of exercising their own control over their work conditions and they have the opportunity to profit or loss based on their own kind of decision making, really they're not economically dependent on the employer for their work, more likely to be an independent contractor. And in the identification of those two sort of core elements or more probative elements in the economic analysis, you wind up with according to the Department of Labor, a clearer set of guidelines, and you're not putting a thumb on the scale of either characterization, but you're providing guidance for employers to make the right call and to make the right classification decision.
So, Lindsay, why is this important? Why is understanding the difference between employee and independent contractor important?
Well, it goes back to what I brought up in the beginning of the podcast, that it can have really significant impact for the employer if an employee or a worker asserts that they were characterized improperly or classified improperly. If someone is classified as an independent contractor, like Scott said, those minimum wage requirements, those overtime requirements don't apply to them under the Fair Labor Standards Act because they're not considered an employee under the Fair Labor Standards Act. So if you are paying them and not considering minimum wage or overtime, and then it turns out on the back end, because of the way they actually operate, because of the work they actually perform for you, they can show that they really should have been classified as an employee. That can be really significant economic damages for the employer that they could owe to that person, particularly depending on, how long of a period of time the relationship has been ongoing. There is a statute of limitations, but, I believe it is 2 years, unless they can prove willfulness, and then it can be potentially 3 years of back pay.
Let me just jump in real quick. So, because I want to just drill down on that. So the statute of limitations that you're talking about, Lindsay, is not the amount of time that someone has to bring a suit, but it actually speaks to the recovery period, meaning the back pay period.
Exactly. Yeah.
Okay. Gotcha. Okay. So, Scott, I interrupted you. What were you going to say?
Oh, just following up on what Lindsay said and how she mentioned previously the exposure under state law, I think there's a potential for a broader period of time, a broader recovery period where you may owe additional back wages under certain state laws. They also have the potential to have treble damages some places. You do have a liquidated damages provision in the Fair Labor Standards Act, so it allows for double damages to be recovered through litigation. The Trump administration actually changed the fact DOL during its administrative process cannot recover liquidated damages anymore under this administration. That's a change from the Biden administration and a change from the Obama administration before the first Trump administration. But now you still can recover liquidated, that is double damages, through FLSA litigation.
And so, sorry, Letitia, just one more thing on that point, because I think this is important. The rule that we're talking about today has been proposed by the Department of Labor, specifically the Wage and Hour Division, as to how they will enforce determining whether someone is an independent contractor or an employee. Courts have also established their own structure for evaluating whether someone is an employee or an independent contractor. So again, going back to what we were talking about, it is really important to sort of be aware of both structures that could apply to you specifically, depending on where you are located, because you could look at the two core factors, but if a court is applying the economic realities test and weighing all the factors the same and just kind of looking at the overall evidence, there's a possibility that they could come out with a different determination than maybe the Department of Labor would. So that is something to just sort of keep in the back of our minds, that this rule impacts the way that the Department of Labor and the Wage and Hour Division will do the evaluation. And the courts, they could adopt something similar along the way, but that hasn't generally been the test that a lot of courts are applying at this point.
And so I just want to drill back down again, because I think this is really, really critical, because if you are in HR or maybe even procurement, or you're in the risk division, it is not sufficient to just Google and ask AI, because you have to know what the courts are saying as well. And I don't know about everybody else, but my test of AI, it doesn't go that deep. They don't go and search all the cases and know. So it's really important to be working with either your in-house counsel or your outside counsel to really, really understand what is required of you in the standards that you should be applying. I want to next jump to Now that we understand that there is this proposed rule and that rule is going to consider two major factors, right? And that's the nature and degree of control over the individual's work, as well as the individual's opportunity for profit or loss. Like, are they really an entrepreneur? Are they really running a business?
Yep.
With respect to that second element there, how would that impact the gig economy and some of the companies that actually run a gig economy platform? And I know this has been an issue in many states, especially with respect to rideshare drivers.
Yeah, for sure. I think one of the stated goals of this NPRM, Notice of Proposed Rulemaking, speaking acronym from my government background, sorry, but one of the aspects of the proposed rule, the clarity piece to provide this sort of core factor guidance, is designed to allow, for maybe more clarity in the classification decision and not to lean towards an employee classification. So it would allow more employers to classify workers as independent contractors, and that aligns with the gig economy. That would include gig workers and freelancers, those kinds of folks who do operate on multiple platforms. In fact, the department right now has said it's not enforcing the 2024 rule in its enforcement activities because it's under challenge in multiple litigations, and now they have their own proposed rule. They're not currently enforcing the 2024 rule at the Wage and Hour Division because it's under challenge in a number of lawsuits, and it's also obviously they have their new NPRM out, their new proposed rule out, but they're referring back to prior guidance, including an opinion letter that addressed the virtual marketplace, as they referred to it, and basically said these sort of rideshare type activities or food delivery software platforms are really that. They're platforms that connect the end user with a service provider. They are not themselves the employer. And so I do think this proposed rule is designed to kind of go back to allowing for easier classification of workers as independent contractors and not pushing in one direction, you putting a thumb on the scale for one way or the other, but it will allow, for more of that sort of gig activity to continue in the independent contractor space as opposed to pulling those folks into the employee classification.
Mm-hmm. And just to add to, what the information Scott is sharing as well, there is actually an example in the proposed rule that relates to the gig economy where they talk about, they provide several examples in the proposed regulation to kind of go through the different elements of the test, one of them being profit or loss. And one of the examples they provide is a company that has their own app-based service, and you have an individual who can increase their earnings by exercising initiative and using the app and investing in their own equipment to effectively provide the services through the app. And they frame this as an independent contractor. Likely this person would be an independent contractor because they do have the ability to increase their profit by exercising more initiative, investing in their own equipment, and providing that service while using the app.
Interesting. So what about, and now this is just a hypo I'm throwing out there, suppose you have a company who runs an ordinary business with an employer-employee relationship, but a certain part or a component of the business, the company says, well, no, these are going to be all independent contractors who come and work in our warehouse, for example. And I'm not naming any companies because I don't know if any companies are doing that, but just for the sake of a hypo here, suppose the company says, well, we want to have this warehouse operation and people, they can sign up through our app to pick up a shift overnight or, and help, store things in our warehouse, but they are independent contractors. Could something like that work where it's the individual signing up on an app and they're saying, I want to take this, somebody has 4 hours worth of work available in their warehouse. Does that in any way potentially implicate some employer-employee dynamic, or is it under those circumstances purely this person picked up the app, they can go somewhere else and pick up a shift? They have that freedom to do that.
I mean, I think everything we're talking about is so fact specific that you really do need to dig in. Not only, I mean, the independent contractor proposed rule does say if these two core factors go in the same direction, you're very likely to land in that classification, right? But there are other factors to consider. And again, when it comes to the economic realities test that is applied in court, that can be different as well. So it's hard to say. And I would also say what you described sounds a little bit like some staffing type companies that have arrived that are more like gig work staffing companies. And I've seen at the state level, different states addressing that in a different way as well, putting liability for certain things on the company that provides for one-off shift type work for individuals just looking for that kind of staffing support to place them. So there's just a ton of stuff going on in that space, and you would really need to dig in into the facts of that specific circumstances to see. I mean, on the face of it, you could say, yeah, that looks like a driver picking up a fare, right? But there may be more to it, and particularly in various jurisdictions that, I'm thinking of Illinois, but I think New Jersey has had at least a pretty strict staffing law. I think it may have been chipped away at a bit, but California, New York, those kinds of sort of jurisdictions may take a different look than the federal government would in that space, and their wage laws may be different than the FLSA in that space. So it really does come down to an intense fact analysis to make these classifications. And to your point earlier, Letitia, that falls on the HR folks a lot of the time, to make these classifications. And I think, again, that's one of the goals for pointing to these core factors is to try and limit the analysis, but it doesn't mean you don't have to do the full analysis.
Yeah.
You have guideposts, but it's not sort of the Wild West free for all. It's still something you have to really evaluate to ensure compliance wherever you're operating.
And I guess under sort of that scenario that I mentioned, you would probably be now looking at the nature and degree of control of the individual once they pick up that shift. Who's supervising them, the person directing their work, etc. So I'm going to give this other example and then move on to our next section in this discussion. But I was at a resort in Florida and happened to be in the lounge area, and the bartender was explaining how he doesn't work for the hotel, that there's an app that bartenders in the area can pick up shifts. And so you might be at, Hotel A on Wednesday and Hotel B on Friday, but they have that freedom and flexibility to pick up a shift wherever there's a need posted in the app. And then they also get the benefit of the tips that come along with that, because depending on the hotel that they're working at or the establishment that they're working at, there's a different clientele. And so the tips might be significantly different. So that's what came to mind to me when you were talking, like, well, what does that mean once that person picks up a shift just to work in the lounge or the bar? Maybe it's not as clean cut as people think, and somebody should be talking to counsel. Okay, so let's move on. All right, so another threshold question that I have, because in my practice, I'm a subject matter expert in traditional labor law. And in that space, the definition of a supervisor really, really matters in terms of coverage. How does that apply in this context? Does it really matter whether somebody is a supervisor in terms of their coverage?
Under the Fair Labor Standards Act?
Correct.
So they would still be covered under the Fair Labor Standards Act, but if they fall into one of the exemptions, like an executive exemption, which can be the case for manager, supervisor level employees, they aren't subject to certain requirements of the Fair Labor Standards Act, like overtime. Okay. So it is important how they are classified and that their actual duties, the duties that they're performing on a day-to-day basis, are carefully evaluated to ensure that they align with the duties laid out for that particular exemption. In this case, the executive exemption. There are other exemptions as well that could pull that individual out of certain requirements of the FLSA, even though they are covered by the law.
Okay, great. Thank you for that. Now, let's talk about overtime and the requirements for overtime. Why don't you, Lindsay, kick us off with this requirement, and people understand, I think, 40 hours or more in a week, or over 40 hours in a week, constitutes overtime. Can you expound on that just a little bit more?
Sure. So exactly right. If an employee is working more than 40 hours per week under the Fair Labor Standards Act, because again, the states could be different on this, but under the Fair Labor Standards Act, if they're working more than 40 hours a week, then they are entitled to overtime. And I think the big issue that we see come up in the context of overtime is in calculating overtime, which is, 1.5 times their regular rate of pay, is determining what their regular rate of pay is. Mm-hmm. Because the regular rate of pay doesn't just mean their hourly pay in many cases. It has to incorporate all compensation during that designated week period. If they receive a non-discretionary bonus because they meet a certain criteria, like a specific deadlines that are set for them, or quantity measurement for certain types of workers, then that's called a non-discretionary bonus. And if they receive it, then that needs to be included in their regular rate of pay. And that's what we see employers really struggle with sometimes, is they just kind of go with the hourly rate in determining the overtime pay, but that's not necessarily going to be the case for every employee. And you have to carefully evaluate what needs to be included in that regular rate of pay.
Yeah, and I want to just clarify that a little bit more, because by hourly rate, you mean their base hourly rate, right? Yep. So if there's a pay differential, a night differential, then that counts toward the calculation of overtime, right? So you can't parse out just the base hourly rate and apply the overtime standard to that. No, you have to also consider the pay differential, and there are many. There's a shift differential. There are, if you do specific tasks, if you on a shift, there could be a differential for that, and you see that a lot in healthcare, especially, and in law enforcement.
Yes. And so in that context, you're pulling together all of that compensation and dividing it by the number of hours they worked that week to determine what you then use for that regular rate of pay, that hourly regular rate of pay, and then evaluating what is 1.5 times that for any hours worked over 40 that week.
That's why it's really, really important to, especially on the labor front, when you are negotiating collective bargaining agreements and you're negotiating and agreeing to all these other differential type of pay or premium pay, that you understand this component too. In terms of how that's going to impact what you pay out in terms of overtime. So you have to be very broad thinking when you are negotiating those terms. It has to be a holistic approach.
Yes, that's a very good point, because I think you're right. In that bargaining piece, you might not sort of be thinking about the overall effect that this could have on how their wages are then calculated moving forward, and that is a really important consideration.
Now, the unions can negotiate that this won't be counted toward overtime, and that's lawful, but you need to agree to that. Otherwise, you have to apply you have to apply the law.
Yeah, I think that's addressed along with some of these other sort of, what compensation goes into the regular rate, and it's like Section 207E of the Fair Labor Standards Act. And there's, of course, a ton of guidance and attendant regulations to that too, but it does lay out how are you calculating, what are you including in that sort of holistic compensation that Lindsay was referring to. And I do think they address, as you said, Letitia, the what aspects of it may be collectively bargained that folks need to pay attention to if they have unionized workers as well.
Yeah. All right. So let's see. What are some common misunderstandings? And forgive me if we already discussed this, but I'd like to get into some anecdotes and some examples of what you've seen in your career in terms of misunderstandings that employers have about the calculation of overtime and some of the outcomes that you have seen where things could have had a better outcome. Scott, why don't we start with you since you enforce this for the federal government?
Yeah, I mean, I think we talked, Lindsay referred to sort of not including the appropriate compensation, all the categories of the appropriate compensation in the regular rate calculation, and that's a big one. But sort of the other aspect of that in calculating the regular rate is all hours worked, as she referred to, and sometimes the compensable hours calculation can be difficult, or folks aren't thinking as much about certain kinds of travel or training that's required for the job versus training that maybe is beneficial but not something the employer is ordering. I mean, you could see your normal commute might be different than being assigned to travel somewhere unique for a day or week. So these are considerations that go into that as well. What is the time worked? Another thing related that just came to my head is the Fair Labor Standards Act does not require meal or rest breaks, which is a difference from a lot of states that do, or CBAs that might. But if you provide them, if you choose to do that, if you say, hey, there's a mandatory, or there's a 30-minute lunch per day, we're going to relieve you of your duties and go ahead and take lunch for a half hour. That's great. You can do that, but you do need to make sure that you meet the obligations. There are regulations covering if that meal break is provided when it is a bona fide meal period, or for a short break of 15 minutes. Is that compensable time? Because it's the employee can go do whatever they want, or is it more likely, given the regs, which are kind of murky on this, but typically a break of less than 20 minutes is going to be viewed as compensable, assuming it hits these regulatory benchmarks. So those are things that, again, like they can sneak up on you as hours worked if they're not hitting the regulatory requirements for those kinds of aspects of the job that you may not think, oh, well, they're not really working during the break, or they're not really working during training, not necessarily, or during travel, not necessarily the case, depending on the facts.
And that's a hard reality, and that is a very common misunderstanding. Mm-hmm. I have heard so many people say, well, I'm entitled to 2 15-minute breaks and a 30-minute lunch. I'm going, where'd you get that? I mean, maybe the state law, but there has to be something that says you get that. And you're saying, Scott, that's not what the law says on the federal level.
It's not, so you're not required, but if you do, no good deed goes unpunished, right? So you need to comply if you voluntarily give leave, or, if you voluntarily give a meal break or, a rest break, you really need to pay attention to what that means to compliance under the regs of the Fair Labor Standards Act.
Right. So let's talk about this compensable time a little bit more, because we're in this new normal where there are a lot more people working remotely, even hourly employees potentially working remotely. And I'm thinking of maybe call center type of employees, right? Now, suppose they have to travel to an office location for staff meetings. Is that travel, would that be considered compensable time if they ordinarily work from home? But, I can see an organization saying, yeah, but your headquarters, where you work is the office, and we just allow you to work at home. What are your thoughts on that?
As I alluded to, the commute, a typical commute is not compensable generally. So, if I think it would be again, a fact-specific determination to say like how frequent that is. If you're obligated once a month to do that trip, I think I'd err on the side of caution and pay that time, because it's not the typical commute from your bedroom to your living room or your home office. But I think, I'll also say I feel like the regs and the Fair Labor Standards Act, even post-COVID, they don't move as quickly as reality. And so there are sort of difficult situations like that have resulted from remote work, that these, again, I referred to the fact that this act came into being in the 30s. It doesn't contemplate remote work. I don't think, and I don't think we've necessarily moved in an adaptable fashion and a timely fashion to consider all these issues. Now, I'm not saying there isn't guidance up there about it, on the website, but again, it's fact specifics. It's jurisdiction specific, I would imagine, as well. But typically, fundamentally, your regular commute is not compensable time.
I love that you said that it's jurisdiction specific, because it may not be a one-size-fits-all for everybody if you are
Correct.
an organization with employees in various states, right? And you're going to have to take into consideration what the requirement is in all of those states, even outside of what the federal requirement is. And so either you're going to have a rule internally where, you're just going to pay for that time. But if your default is we don't want to pay for that time, well, you have to get a little bit more specific in terms of the circumstances and your location. And again, my point in asking that question is really to drive home the point that you can't just make these assumptions. That no, you work from home and you're required to come to the office, and the office is your real location of work, and so we don't have to pay you to come in. No, you need to be engaging with counsel so that you can understand what your rights and obligations are as an organization.
And it relates a bit, Letitia, to what sort of we alluded to about, training. Is the training a requirement? Is this in-office meeting a requirement that is outside the typical obligations of the employee who, as you said, their work location is generally remote? They may be attached to an office, but do they really go to that office? Or is this a one-off or a monthly meeting that requires a different work day for them, where they have to make a trip that isn't part of their usual course of business or their usual workday? I mean, those kinds of things need to be thought about.
100%. What about when you have someone, going back to that call center, because we're having a lot of that nowadays, right? And someone sits at their cube, or let's just say they're a remote worker. And they sit at home and they eat the lunch and they take calls or they check emails while they're doing it. Can you tell us about that? Is that compensable time?
If they're working, it's compensable time. I mean, even if they're supposed to be taking a break, even if they are told you are supposed to be completely relieved from your duties during this 30-minute period, if they are not, if they are responding to emails, if they are doing work, then that is compensable time.
And this is important. Why? Because it could kick you over into overtime. Now you're in time and a half land. Right? That's why that's so important, because an 8-hour shift is going to turn into 8.5 hours over the course of the week, which is going to kick you over that 40 hours, right, in a week. So, Lindsay, compensable time. We've heard a lot about that, and I've seen that happen a lot where the organization says, well, we don't really pay overtime. People get comp time. And so they can use that comp time to take extra time off of work or to leave early or come in late. Can you tell us about how lawful or not that is?
That is generally not lawful for your non-exempt employees. Yeah, I mean, I've heard that too. And the tough thing, I think, a lot with that discussion is that employees want the comp time in a lot of cases. And so employers feel like they're doing something helpful by giving that option. But under the Fair Labor Standards Act, if you have a non-exempt employee who works over 40 hours in a week, they are entitled to overtime, and you have to pay them that overtime. You cannot substitute that overtime for comp time.
Right.
It's also confusing because the federal government allows it. I mean, there's an exception for public employees under the Fair Labor Standards Act. And Letitia, I'm sure you could speak to the fact that there are aspects that can be collectively bargained around that too.
Yes, yes. Although I don't see that. I have not seen in my career, you could say we don't want our people to get overtime pay. We want them to get comp time. I have not seen that. But like you, Scott, I came from the federal government as well, and comp time is a very real thing.
Yep.
All right, especially when you're a trial attorney and you're working these wild hours, and it's okay. Well, we'll give you comp time for that. Okay, so now let's talk about. Here's another good one. Well, the overtime wasn't approved, and we didn't pay it because nobody in HR approved it, and the line supervisor or the frontline supervisor didn't approve it. So therefore, we shouldn't have to pay it. Can you demystify that for us?
No, you have to pay it. It's hours worked. If it's hours worked in addition to 40 in a week, over 40 in a week, it's compensable time at the overtime rate, whatever the regular rate times 1.5 is. You can't take away someone's FLSA rights to overtime. They can't waive them, and so you'd have to pay that overtime even if it's not approved. Now, the way to address that is probably through coaching, training on your policies. So there are ways to manage the situation, but not through failing to pay appropriate compensation.
Yes, I've seen that. I've seen the coaching and outright discipline sometimes because if we have counseled you many times about compliance with our time and attendance policy, then if you keep just working overtime and staying late because that's what you want to do, then that's a violation of our policy. And so I've seen that happen as well.
Yep.
All right, so now let's dive into some of the exemptions. Lindsay, will you kick us off by explaining why the exemptions are important and then what some of the exemptions are?
Well, I touched base on this a bit in a previous response related to supervisors and managers under the FLSA. But exemptions are important because if employees fall into one of the exemptions, then they aren't entitled to overtime pay. So they, as far as tracking their time, it doesn't need to be done in the same way that it does for your non-exempt hourly employees. You have to closely track their time to ensure they're being paid for all hours worked. In the case of an exempt employee, they're being paid a salary. That's part of falling into the exemption. And they're going to be paid that salary no matter the hours that they work. And, there are some nuances around that, but generally that's the case. No matter the hours they work in a week, they're going to be paid their salary. But then again, from the employer's perspective of potential overtime payments, they don't have to be paid for overtime if they do work more than 40 hours in a work week. They're still paid their regular salary.
So I want to just drill down on that a little bit more, because suppose you have, and we've seen this in our careers as well, that you have an organization that says, well, we have this salary exempt professional and they didn't work a full week last week, so we're going to prorate their pay. Can you talk about that?
That is not permissible to prorate their pay. They have to be paid their set salary. That is part of falling into the exemption. So if you do things like that where you try to prorate their pay, I mean, they're going to fall outside the exemption because they're not being paid in the manner they have to meet the exemption. So if they work that week, even if they work less than the 40 hours they're supposed to, you still have to pay them the same amount. Now they're, if they have sick days, vacations, things like that, that's a little bit different. But if they just haven't been as productive in a work week as they're supposed to be based on, the agreed upon hours they're supposed to work, that doesn't matter. They still need to be paid the salary that's been set for them.
And just to be clear, Lindsay, I think you kind of alluded to this, but there is a weekly salary threshold, there is an annual salary threshold, and there is a duties test for these exemptions. So if you need to fall under one of them, you have to hit those sort of three. I think you've referred to it as like a tri-legged stool in the past, Lindsay, and we don't have the picture, but usually you have a graphic, I feel like, when we talk about this. But, if you miss any of those legs, the exemption goes away. And so it needs to be clear that you're meeting all three of those. And the duties test varies under which, kind of exemption you're trying to claim. But I would say, on that point, DOL recently clarified it's the employer's exemption to claim. So I think an employee was asking about whether she still fell under an exemption, and whatever the end result, a point that DOL made in this interpretation letter response, which is one of the big compliance assistance tools they're pushing in Trump 2.0, they said, it's the employer who gets to say. So even if an employee meets all three of those things, maybe the employer, for whatever business reason, does not want to claim an exemption over that person. They decide, no, we'll pay them overtime if that happens. So it's something to think about, too. It's not something the employee has a right to claim for themselves. It's the employer that can claim the exemptions under the Fair Labor Standards Act.
And that's, typical in a collective bargaining setting, right? Oftentimes you have professionals that would ordinarily qualify for an exemption still treated as an hourly employee for the purposes of overtime. And that's something that's collectively bargained. And so the employer, I think, as you're pointing out, has decided that it's giving up that right to claim an exemption, right, and saying it's going to pay these employees overtime. You see that a lot in healthcare with nurses. You see it a lot in public safety with police officers as well. But I want to go back because I think sometimes, because we are attorneys and we do this all the time, we understand sort of the framework and the baseline things, and we can sometimes skip over something. Because I don't think that at the beginning of this podcast, we said, what is the federal minimum wage for hourly workers? Can we start there?
$7.25.
And it has been that for a very long time.
Yeah, it's $7.25 an hour.
And there are some states that are still, they have aligned with the federal standard, or they don't have their own standard. They just follow the federal standard. And then there are states that say, well, no, the minimum in the state, that's what, the federal government said is the minimum. But the minimum in this state is $20 an hour, right? There are
Correct.
some locations that have a much higher threshold.
A lot of states
and I think that,
have a much higher threshold.
Sorry, yes, that's true. And I think there are actually some that just never updated when it went to $7.25. So their state minimum wage is actually below the federal. Of course, you're going to have to pay that federal. Don't follow a state minimum wage that is less strict. The federal, again, floor, right? And
Right.
If you come into conflict between the federal and a higher state, you need to pay the higher in the jurisdiction you're operating in. Again, federal is the floor, and you're going to need to pay that at least wherever you're operating.
All the smart people in the room, we didn't touch that one thing. So I want to make sure we get there, because next I'm going to ask you to now explain the minimum for the exemptions. But Lindsay, you were going to say something.
I just wanted to add real quick, just because I think this is important as well. We're talking about the fact that states might have different requirements for hourly pay, for, certain aspects of just general wage and hour law. There are cities and counties that also have different minimum wages. So that's really important to know as well. If you happen to be in one of those counties, if you happen to be in one of those cities that have set a different minimum wage, that might even be different than the state's minimum wage. That is what you should be paying when you are operating in those locations.
That is very common, especially in places like California. You might have a county or town or city, municipality specific minimum wage. And so you have to meet that minimum wage, not just what the state set, right? And those are
New York City City Council just proposed legislation that would gradually raise it to like $30 an hour in the city, which is obviously not the same as the state. And I think New York, you mentioned California, but I think New York State also has different minimums in a number of jurisdictions, but also has different, and I think you were about to get to this, Letitia, but the thresholds for the exemptions are actually higher than the federal. And so you can see that as well, meaning more people would be entitled to overtime when their salaries don't meet those thresholds.
So why don't we talk about that some more here, the threshold minimums for the exemptions. Scott, can you tell us about that weekly versus annually? And again, going back to Lindsay and Scott, can you just share with us some of the more common exemptions?
Sure. So the threshold salary levels, the weekly is $684 per week, which translates out to about $35,568 annually. During the Biden administration, there was a jump because he passed a rule raising those, and there was going to be a second raise. The rule got invalidated before the second raise, and we reverted back to what the Trump levels were, which were the ones I just read. And those are the obligations right now. And those are in effect generally for the executive, administrative, and professional exemptions to the Fair Labor Standards Act. Lindsay spoke a bit about the executive. You're looking at managerial folks. Admin, you're kind of running certain operations of a business. Professional would be folks like, the two of you, and then I'm also somehow lumped in as a professional. It's weird. I don't see it that way. But, it would be folks like lawyers or, academics, other doctors, things like that, where there's a course of learning that's required generally to operate in that role. And so those are the most common. There's some for IT. There's some sales related roles that can be exempt. There's one of blanking. Oh, the highly compensated employee, meaning you're sort of meeting some of the duties test pieces, but your salary is even higher than that 35 number that I just mentioned. It's I think 106,000, something like that now. So it would be for folks who have a high rate of compensation. But I will say there are cases out there. Was it Helix relatively recently that even if you have this high compensation, you still have to meet those other legs of the stool. So you can't just say like, oh, I'm paying this person a ton, they're never going to get overtime, because that isn't necessarily the case. You do have to meet it all, and if one falls, all fall. So that's something where exposure certainly can be high. If this person's rate of pay is that high, you can imagine their overtime regular rate will also be pretty high. And so, even with folks who you're paying on a salary basis that work irregularly, consultant type people, if they're not independent contractors, which maybe they are, but if they're just, employees who are highly compensated, but on a sort of project by project basis, all of those kind of factual analyses and circumstances really need to be considered when you're making these classification decisions.
That's really important, Scott, because I can't tell you the number of times I've done wage audits for organizations, and the number of times someone says, well, this is an exempt position, and you're reading the PD, the job description or position description, you're going, well, based on what? Well, because we said so. And I'm going, that's not what the law is. Like, you really have to look at the duties of this individual to make that determination in terms of those exemptions. And at least I found that it was rare that someone was actually really looking through the duties and looking to the standards as defined by law, not as defined by what we have a gut feeling about.
Well, and even if you have a great job description, if that's not what the person's actually doing, you really need to look at those things and say, like, what is this person's role on the ground? Are they really performing exempt activities? We don't just have like a pristine description of the job. We actually are aware of what this person is doing on a day-to-day basis, because DOL, other wage enforcement, state entities, they're not going to care about the title or what the job description says. They're going to find out what the person does, and that's going to be what's the operative analysis and an enforcement action.
At the same time, though, I would emphasize the fact that it is important to have a job description that accurately defines the expectations of the position, because they are going to look at that. So it's good to have it in order and that it's accurate to what that person is actually doing. But it is also helpful for the employer themselves and for that individual in setting those expectations. And, if you expect this person to be actually supervising or managing at least two full-time individuals to fall into the executive exemption, you should be taking steps to make sure they are doing that is being fulfilled. But the job description is a really good place to sort of set those expectations so that in practice, they are actually doing it and they know what they should be doing. And, to Scott's point about title, I think that's where I've seen, questions in the past too. Well, they have the title of supervisor, they have the title of manager, so they're exempt. But they actually have to meet all of the duties requirements. Like Scott said, the title isn't ultimately what's important. It's good to have accurate titles, but just because they have the title of supervisor or manager, that doesn't stop the inquiry. You really have to dig into what they're actually doing.
That's really important, not only in this setting, but also when we're talking about complying with federal labor law. So many times, companies mistakenly believe that because someone is exempt or they label someone exempt, then they don't have the protections of the National Labor Relations Act. They are not a statutory employee and therefore they cannot be in a union. That's not the case. Exempt, that is not one of the criteria that the board evaluates in determining whether or not somebody is an employee, right? And also title. Sometimes people think mistakenly that if we call this person a supervisor, then they are a supervisor under federal labor law, and therefore they are not employees entitled to the protections of the Act, including the right to form, join, or assist labor unions. Now, just because you put a title on someone, they have to have at least one of the 12 supervisory indicia, which are defined in the National Labor Relations Act itself and further fleshed out in board case law. So just looking to job descriptions and titles and exempt status alone is never a good idea.
And I think that, I just wanted to highlight that point. That was what I was trying to say, and Lindsay refined it by saying that stuff should be aligned with what's happening. I mean, all of it matters, right? But you can't just rely on the paper. You have to do the extra work that ensures the paper is accurate. And I think that's really important, to not just rely on, whatever's on the person's business card or whatever their job description read when you hired them. Like, revisit that stuff. Make sure it's still accurate. If jobs have changed, duties have changed, you need to make sure that exemption is still appropriate, right? And I think making sure you have current job descriptions, current titles that reflect the on-the-ground activities of these employees is really key to mitigate your enforcement risk.
Love that. Okay, so we are coming on time here, and before I let my very informed and expert guests go, I want to talk about internal auditing, and I think we just sort of touched on it a little bit here, and preparing for a Department of Labor investigation and what that investigation process would look like. Take it away, Scott and Lindsay. Help us understand those components.
Yeah,
Lindsay, do you want to speak to it first, and I'll
speak to. I'll let you sort of talk about the wage and hour audit piece of it, because you have, sure, I think, some good experience on both sides, with those types of evaluations. To just sort of add to the information that Scott already shared about what types of internal auditing you could be doing, I think another really important piece, you're looking at your job descriptions, and as part of looking at your job descriptions, you are closely evaluating what those employees are actually doing. You're talking to employees. You are talking to these people that you've classified in different exemptions to make sure that they are actually doing that. You're talking to their managers to make sure that they, in the case of an administrative employee, are actually exercising independent discretion. All of those things are important in sort of evaluating that exemptions have been properly made for your employees. Another really important piece from the FLSA perspective is auditing your pay practices. Are you tracking employee time? How are you tracking employee time? Are there checks on that? Are someone reviewing this and making sure that the policy that's in place is being properly implemented by those who actually have to implement the time tracking, review of overtime, and to sort of have all of that record keeping in place. There's certain documentation that you have to show that you're tracking all of these things. So taking some time to sort of review your policies and practices, review whether they're being implemented as they're supposed to be, and then also, checking on, is overtime being properly calculated? Are we considering other forms of compensation and how we're determining the regular rate of pay, and how are we doing that? Those are all really important steps in making sure that your pay practices are accurately capturing all time and then resulting in the pay that the employee has earned based on all forms of compensation and that regular rate of pay.
And I would say, before you jump in on the DLL process, I would say that make sure that this is happening. If we're talking about a payroll team or HR team, that this isn't happening in a vacuum, that other people responsible for enforcing or monitoring compliance with pay practices and the law, that everybody is included and on the same page. And then I think it's a good idea to have something with, and you might want to have counsel assist you with this, so you have some sort of privileged document, but something that explains your rationale, why you landed where you landed on certain things. Because especially in the management ranks, there can be a lot of turnover. And you might have someone who starts 10 years later, right? And they're going, well, how did we end up here? What was the decision-making process? And having that privileged memo somewhere would be helpful to informing those who are now the decision makers or who are now defending the company.
Absolutely.
Yeah, I think that's right. Consistent processes, applied uniformly and in good faith, definitely are helpful when you're mitigating the risk of an inspection from someone like Wage and Hour. They can show up and request records. The records Lindsay alluded to, it's really important to keep accurate records. And, we work with employers who are trying to do the right thing, but the right thing isn't always the lawful thing. So, you really need to pay attention to the kinds of records you need to keep, how they should be maintained, what they look like, how you're tracking hours, the compensable time we talked extensively about. And then, be prepared for Wage and Hour or some state enforcement agency to show up. Don't just kind of wing it. Have a plan. Who's controlling the records? Who is, figuring out what needs to be produced in response to requests from the agency? Who's meeting the person at the door when they show up for an on-site visit? Who's coordinating employee interviews? All of these things. You should have a team that is ready to do that, and you have a point of contact who knows how this process should go. And, to the point about internal auditing and putting the privilege around that, consider whether and when to call counsel to serve that gatekeeping role, to help you coordinate the employee interviews, to sit with management witnesses during interviews, to discuss employees' rights and obligations during an inspection, to manage the information flow in response to requests. All of those things, we have experience doing these. We try and develop a good rapport with the investigators in our matters so that we can work towards what really is the shared goal of both the investigator and the investigated, to promptly and accurately and efficiently resolve the investigation and ensure compliant practices and ensure folks are getting paid. Everybody has those goals, right? Where we should be, to the extent we can be less adversarial and work towards that shared end. I think it's helpful to kind of set those expectations early, be reasonably communicative and responsive, and work with the investigatory agency, because it's the benefit of our clients, the employers and the employees, to get this stuff done efficiently.
And don't go it alone. Do not, I cannot tell you, in my career, employers or companies that think that they can go it alone, that they could just handle the federal investigator. You can't handle them. You can't. So you should have appropriate counsel assisting you with this process, because the government's role is enforcement of the law, investigating and enforcing the law. Your business interests are going to be protected, and considered by your counsel and advocated by your counsel. So that's the role of your counsel. It's not the role of the government. So that is really key, to not try to go it alone. Scott, you talked about employee interviews. And I started my career before I was an attorney. I actually started with OFCCP, which is, it's probably a minuscule organization at this point. But we used to do these audits. We used to go on site and do on-site audits, or we would do desk audits, and we would look at payroll data. And sometimes we would want to talk to employees. And there are times when the organization says, well, we think a manager should sit in, or a supervisor should sit in on an interview. Does the DOL process allow for that? Because I know in the NLRB space, that's not going to happen. That's a non-starter.
Yeah, and that's why I said, see if you want counsel to sit in, participate in manager interviews. Because typically with wage and hour, they're going to be entitled to a private conversation with, an hourly line employee, not to someone who can sort of bind the company with the statements they make. I will say, something that isn't always said, and I'm not saying there's any nefarious intent behind it, but, an employee can ask for someone to sit in with them. But they need to make that ask. And we always tell them that. This goes for OSHA investigations or wage and hour investigations. I always advise employees, that they can ask if they want someone in there. Again, DOL is going to say, we'd love to talk to you in private. And we're not going to say, or the employer is not going to say, no, we want a manager in there. We're not going to coach people. We're not going to take any action against someone who participates in an investigation. Those are all, sacrosanct, and the investigator has rights, the agency has investigatory and enforcement rights, but employees have rights too, and they can say, I'd like my manager to sit in if that's the case. I'd like my mom to join if that's the case. I'd like corporate counsel. Mr. Hecker seems really nice and he wants to sit there. That's fine. All of those things, they can ask for that. But that's
very different from the NLRA and the NLRB. I just want to put that out there.
Yeah, that's fair.
You don't want employees marching in and say, we want management to sit with us.
And I've had investigators make that representation to the employees, but it doesn't always happen. And so I think we like to, tell our clients there's some rights that employees have. There are also responsibilities employees have, to tell the truth, to, accurately describe the circumstances. If they have said they're going to participate, and again, it's their right, at least in the initial stage, whether they want to speak to an investigator. Certainly an investigator down the line could subpoena a conversation with someone if the person didn't want to voluntarily participate, but that's the employee's decision also, not the employer's. All those things, there are rights and responsibilities, and we try and make sure that folks know that. I think often, the enforcement agencies also explain those rights as well, but, we just want to make sure they're said in the event that, they somehow fall through the cracks, and the employees know, if they make the choice to participate, they should speak the truth. I'd rather have that than them trying to say what they think I want them to say or their employer wants them to say. It's better to deal with facts than it is to deal with falsehoods or surprises.
Or feelings. Because the feelings are not facts. Feelings are feelings.
That's
so that is great. And Scott, I think this deserves a follow-up episode on just the investigative process, because I think a lot of information and education is desired around, what do? I got a letter, there's an investigation, there's some sort of complaint out there. What do I need to do to be prepared for such an investigation? And with that, we are at the close of another fun and engaging yet informative episode of Terms and Conditions, a podcast by Maciel Carey. Again, I am Letitia Silas. I am in the Washington, D.C. office, and for this discussion on FLSA and why it's important to your organization, I was joined by my esteemed colleagues, Lindsay DiSalvo and Scott Hecker. Thank you so much.